Great. Anthony Cox and Destiny Peters Ritzenthaler. Okay, looks like you're Mr. Cox. Okay, good morning, Mr. Cox. I'll ask if
I'm on Zoom.
okay, so we have Miss, and do you prefer that I refer to you as Ms. Peters or Ms. Peters Ritzenthaler?
Peters. It'll be easier to say.
True. Okay, so we have both parties present. I'll double check to see if Ms. Corey is on the line, the guardian ad litem point. We're on today for an interim review of the guardian ad litem report. I show that it's scheduled for a final report to be completed on November 20th of later this year. So let me just touch base with the parties. Mr. Cox, have you had contact with Ms. Corey?
Yes, I have.
Okay. And have you been sharing information and providing whatever documents she's requesting?
Yes.
Okay, great. And then Ms. Peters, have you been in contact with Ms. Corey?
Yes.
Okay, kind of same type of question. You're responsive to her requests and providing whatever information she might need?
Yes.
Okay, that's great. As far as our review today, that's pretty much what I wanted to make sure that the parties are both in contact with Ms. Corey and that she has enough information and contact information to gather the information that's critical for her report. Do either of you have any concerns regarding what's happening with the guardian ad litem process, Mr. Cox? Okay. Ms. Peters, same question.
No concerns.
Okay. All right. Well, I'm not sure where Ms. Corey is. She didn't file anything in preparation for today, which is not uncommon. So I think what we'll do, having heard from both parties that they've been in contact with Ms. Corey, I think we're fine, because let me just double check. The order that appointed Ms. Corey says we will review. It says review contact and any temporary contact opinions on September 11th. I think it says contact. It's hard to understand the writing. Mr. Cox, did you recall anything about that from the guardian ad litem order that was entered back on July 31st?
Because I was explaining that I was trying to get temporary custody still, and so he said that we talked about today.
Okay.
Obviously.
All right. So I guess it's just a little bit more than what we had talked about, more than just making sure that both of you had been in contact with the guardian ad litem. I'm not sure where Ms. Corey is. Madam Clerk, have you had any communication from Ms. Corey? Nope. Okay. No updates there. I think we probably should come back and just revisit this in just a moment. We'll give her just a few minutes to get on. Sometimes they have other dockets they're assisting with. Would both of you be available if we called it in 10, 15 minutes?
Yeah.
Okay, great. Thanks for your patience. I'll put that in kind of the hold and come back to file, and so we'll call it up just a bit. I'll ask if Desiree Kamba is on the line. Desiree Kamba. All right, no response. Ruben Kamba, are you on the line?
I'm here, Your Honor.
Okay, welcome to you, Mr. Kamba. All right, so Mr. Kamba, you filed it looks like a motion for contempt related to the non-return of your child, and it looks like there was some issues related to service. I showed that there was an order to serve by mail that was signed off on, allowing for service at the Rochester address.
Right.
And then it looks like on September 10th, there was service by mail on September 4th to that address. And it looks like you sent it on September 4th, correct?
Right.
All right. Just pulling up the case file, just a moment. Bear with me one moment. I'm just taking a quick look at the our local rule related to timing.
Also, Your Honor, I did pay for a private investigator to locate her, and I had the investigator give the detective that information.
Okay.
So there is a new address for her.
Which whereabouts? Do you have a kind of a general idea, or more specifically?
Tucson, Arizona.
In Tucson. Okay. And then with that private investigator, if with kind of that tracking her down, has the private investigator been able to serve her with any documents?
I don't believe so. My concern is when she found out that I was getting custody out of him, she moved out of state to begin with, and if somebody were to show up at her new apartment, she might decide to take off again. given the history of what she's been doing.
Right. Mr. Combo, in the past, we've talked about potential on your end, potentially getting in contact with legal aid or an attorney to help you in the process. Because we've talked about in the past how, you know, if she's withholding the child and ran with the child to a different state, there's certain steps that need to be taken and then presented to the court in order to get some type of order that would allow police to take her into custody. Have you made any contact with an attorney?
I did contact the free attorney that you guys have, but I haven't been able to really do anything with that. I think I'm gonna have to give them another call with all this new stuff and see if they can help me with that. But I mean, she's been in contempt this whole time. I haven't seen my son in it like a year. So,
Right.
yeah, I don't know.
Okay. All right, thank you. Just one moment. I'm going to take a look at that timing rule. So, Mr. Kamba, I know you've been working really hard on this case, and it's been taking way too long. The order to allow service by mail that was served on August 15th, I believe, was the date it was signed, and that date, in conjunction with today's date, would have been sufficient time under the rule if she would have been timely served. With the mailing of the document, it was mailed on the 4th of September to the Rochester address. That doesn't comport with the timing rule. So we're here a bit premature. I recognize that the service has been effectuated to that address. However, from the 4th of September to today, that's only 7 days, and there needs to be 21 days under that local rule. So what I'm suggesting, and I apologize for this, is to move the matter from today to 2 weeks from now, which would put it at September 25th, and that would be sufficient time under the rule. And if we haven't heard from her at that time, then I can go ahead and issue the contempt order that you're seeking. So do you have any comment or thoughts on that?
Yeah, the reason I sent it on the 4th was you said that it would be sufficient time for her to receive that paperwork for this week's court, since last week she wasn't able to go do it because she didn't receive the papers, obviously. So would I be having to serve her address in Tucson is my question?
No, not necessarily. I mean, the service that there's a motion that allowed service via mail to the Rochester address, so that's sufficient. And if you can serve her in the Tucson, that gives her other opportunities to respond, and also kind of what you said also, that it potentially would encourage her to leave or relocate. So from my vantage point, if we set it over 2 weeks, there's proper service, and then we come back in 2 weeks, that allows enough time to have passed under the rule to allow for the court to enter your requested relief, barring her not responding.
So my question is, what would I need to send to the mail, or what would I need to serve her? Because would it be just like the same papers again?
Well, so for the next hearing on the 25th, there's no further need of any service. If you are, it would be good to have in-person service on her, and to have you could potentially serve a motion for another contempt, for the kind of continuing contempt, or for withholding the child. And that would at least give her that personal service, and that gives a little more grip, if you will, to bring her to court and take the next steps potentially of asking police to bring her into custody and bring her and the child back home. So that's one thing you could do. You could note it up you could file a new motion for contempt for the new period of non-compliance, and you could serve her with that information. Otherwise, we'll just be back here on the 25th, and likely the motion for contempt would be granted at that time if she's not responded.
Okay, so I could still send that to her mother's address, a new motion for contempt.
Yes.
Okay.
Okay.
All right. Yeah.
So we'll be back on the 25th at 9 a.m.
All right. Thank you, Your Honor. Great.
Thank you, Mr. Kamba. Okay, welcome to you, Mr. Kamba. I'll ask if Desiree Kamba is on the line. Desiree Kamba, if you're here, state your name. Okay, Ms. Kamba, I can't hear you, so if you are speaking, Desiree Kamba. make sure that you're unmuted and again, state your name, Desiree Kamba. We're on here on to, not hearing a response. There's no movement in the courtroom, so she's not here in the courtroom. This is Mr. Kamba's motion for contempt. Service was mailed on August 27th to an alternate address, so service is proper upon Ms. Kamba. And this is related to a request for contempt for withholding of the child based on the June 2023 parenting plan, and that you're asking for costs of the $5,000 of private investigator fees. Can I just ask you, I'm inclined to grant you the contempt, Mr. Kamba. I wanted to ask you about the private investigator fees. Do you have any documentation related to that, as, invoices or payments of anything of that nature?
He did send me a way to pay online. I'd have to go to my bank and get a screenshot of the charge.
Mhm.
And it wasn't $5,000 for it. It was, I believe it was like $150 or $160. But all the other fees for like my process server and everything, um, she still has to get paid. It's taken a lot of work.
Okay,
So
so the private investigator fee was about 150, 160.
mhm.
And then your process server fees, what of those? What total or what amount is that?
Um, well, it would be the rest. So about $4,000.
And do you have invoices related to that? Because generally, I'm not averse to awarding those fees. I just need some support or foundation for it.
I don't have an invoice for it, no. My process server, she is here in the court
Oh, she's in the car.
waiting also, and um, so
Oh, is she on Zoom? Did you say?
yes,
Okay, what's
yes,
her name?
Sabrina Clements.
Okay, Ms. Clements, are you on the line?
Yes, I'm here.
Ms. Clements, have you submitted an invoice for payment for your process service fees?
Not as of yet, but I can do an itemized list of that. It's just going to take a little bit of time because I've been doing this since June of 23.
Okay.
When he lost the attorney, I picked up doing all documents and all services.
Do you have an estimate of what your fees are at this point?
Um, I would say probably about, with my time of service and trying to research where she was in our area, um, probably about at least $3,000 with fees and time and drive time and all of that stuff.
Okay. Okay, so Mr. Kamba, I've read over, I'm familiar with your case and your motion and the concerns that you have related to not seeing your son for a significant period of time. So I'm granting your motion for contempt, that the order of June 2nd, 2023 was not followed by Ms. Kamba, in that she didn't follow the parenting time schedule and other parts of the custody order as you described in your motion for contempt. Making a finding that there is bad faith, that she's left the child apparently out of state, not allowing any visitation with father. And the issue as of the fees and the like I said, I'm inclined to grant that, but I need some type of documentation related to that. So what I'm putting there on the order, I'm putting reserved. Reserve means basically you can, if you bring back that documentation, then we can take a fresh look at it. So I'm just putting reserved upon a showing of documentation. I'm just writing that in the order. And I'm just going to make clear that it's not lawyer fees we're talking about. We're talking about a private investigator and process server. I'm just making that notation on both pages, so bear with me. So we'll make that finding of contempt. Then in your proposed order, Mr. Kamba, you asked for 1,000 days in jail in the Calais County Jail. Is that correct?
Yes, and the reason being is she's choosing to take this time to do the most to keep him from me. Um, since it just, yes.
So we've talked about this before, Mr. Kamba, the difficulty of her not being in the state and the child being with her. What I've traditionally have seen, and this is where I've encouraged you to reach out for legal assistance from an attorney. What I've seen in the past when a parent absconds or takes a child out of state in contravention or against a parenting plan court order, there's a long series of efforts that need to go into that to get a warrant issued and make it an interstate extraditable warrant, to get law enforcement involved. It's a fairly involved process. And that's why I encourage you again to seek out legal counsel to assist you in that process. Because at this point, yeah, I can order jail time, but it's not effectuated until she's here in front of the court. So I'm not going to order the jail time. I'm going to indicate that jail time is reserved. But again, just strongly encourage you to seek out legal counsel from an attorney to assist you in the process, because the ultimate goal, I think, is that if she's out of state, as you indicate, and she's withholding the child, then to get her back, if she's not going to come back willingly, then law enforcement would have to get involved and arrest her and bring her back along with the child. So that's an involved process, and it's takes some experience to get it and get it done right. So I'm signing off on the contempt order. And then again, I just encourage you to reach out to counsel to assist you with the next steps in order to get her here and the child back. So go ahead.
From my understanding was I was just waiting for the prosecutor to look at the paperwork and re you know put the warrant out for her arrest. And
Yeah, that's another option, that a prosecutor could file a custodial interference charge and then seek a warrant, extraditable warrant. That's one option. There's a civil aspect too, that if you wanted to go that route, that's where my encouragement comes on that end.
yeah, I already she's already have that as far as parental interference. So what I was saying was I was just waiting for the prosecuting attorney to re-put that.
Okay.
Unfortunately, they're on vacation until sometime mid-October. Tried contacting the prosecuting attorney that is currently handling, where the other person's missing out on because they're on vacation. And so I was wondering if that's all I'd be needing, because I mean, she's in contempt. There's a warrant for arrest. I found her address. Uh, is there, like, because I already contacted local police, so they're supposed to be contacting Tucson police
Okay.
to help with that. So
Yeah, so at this point, I think those are your two options. You can seek the assistance through a particular prosecution, or you can follow the suggestion of hiring private counsel to get some type of civil extraditable warrant. So at this point, I'll let you work through that. I've signed off on the contempt order, and that'll be filed. If you need a copy of it, you can check with the clerk's office. So that'll conclude the hearing for today. Thank you. That helps. Thank
okay,
you.
thank you, Your Honor.
And I'm making an assumption
Next I
that you're
have
Christopher Brooks?
Yes, sir.
Okay, very good. And then is Kelly Grandchamp Brown present?
She's present in my office. Amy Powers appointed to represent Kelly Grandchamp Brown.
Great, thank you, Ms. Powers.
Does the court want me to unblur my background so the court can see Ms. Grandchamp Brown, or is it okay to leave it the way it is?
Fine how you have it.
Thank you.
All right, so we are here today on Ms. Grandchamp Brown's motion, what appears to be a motion for appointment of guardian ad litem, and I'll just confer with Ms. Powers, making sure that it's not, is it expanding into a parenting plan or just for the appointment of the guardian ad litem?
We're asking for three things today. We're asking for a temporary child support order. We're asking for changes to the temporary parenting plan, and we're also asking for appointment of a guardian ad litem.
Okay. Okay, so I reviewed the financials, I've reviewed the proposed parenting plan issues that you've raised. And okay. All right. And then Mr. Brooks, just double checking with you. Is that your understanding of those are the issues that we're talking about today?
I was under the understanding when I talked to the clerk that this was just a response to the parenting plan that I had filed.
Okay.
The altering the temporary parenting plan. I mean, like, I don't agree with it. I'm going from Tuesdays and Thursdays every other weekend for her asking for 1 day a week.
Right. And
yeah.
Yeah, and I'll give you plenty of time to talk about that. We just want to kind of make sure we're on the same page as far as the issues that we're going to be talking about today.
Yes, sir.
Okay. So with Ms. Powers, on behalf of her client, I'll hear from her first, and then I'll hear from Mr. Brooks on those 3 issues. Go ahead, Ms. Powers.
Thank you, Your Honor. I represent Kelly Grandchamp Brown. These parties began a relationship in 2019, and they have 1 child together, Jaden, who is age 2. Mr. Brooks spent time in prison and was there when Jaden was born. He got out of incarceration in late 2023, and that is when he met Jaden for the first time. He also began some visitation as agreed by the parties. The parties were initially still together when he was released from incarceration. In February of 2024, Mr. Brooks took Jaden and kept him and refused to return him to Miss Grandchamp Brown. Additionally, Mr. Brooks—
What was the period of that time of the time of withholding?
It was in February 2024. I believe it was for a few weeks. He filed a protection order. The court denied the protection order on March 11th, 2024, and indicated that the parties needed a parenting plan. I do have the protection order cause number if the court would like that.
No, thank you.
Okay, so that was a few week period of time. The court denied the protection order on March 11th, 2024. Mr. Brooks had not established parentage at that time, so the parties did work together and established parentage and entered an agreed parenting plan on March 28th, 2024. In this agreed parenting plan, Miss Grandchamp Brown is the primary parent, and Mr. Brooks has time with Jaden every Tuesday and Thursday from 4 p.m. to 8 p.m. and every other weekend from Saturday at 10 a.m. to Sunday at 6 p.m. Around May of 2024, Mr. Brooks stopped following the schedule and started canceling visits due to working 2 jobs. Now, the parties both make different allegations about why visitation became disrupted in that time period. Ms. Grandchamp Brown alleges that Mr. Brooks was not exercising his visitation because he was working 2 jobs. Mr. Brooks alleges that Ms. Grandchamp Brown was withholding Jaden. So we had this period of time beginning in May where visitation was not regular. On July 23rd, Mr. Brooks exercised his visitation and there were no problems noted. The next visit that he exercised was August 6th. At that point, Mr. Brooks withheld Jaden again and filed another protection order against Miss Grandchamp Brown. That protection order went to hearing on Monday, September 9th, and the court dismissed it with prejudice. Ms. Grandchamp Brown also filed a motion for contempt because of the withholding. That hearing was held on August 27th. The court did not find contempt based on the text messages that had been filed by Mr. Brooks, but did order the parties to start following the parenting plan as was. Under that parenting plan, Ms. Brooks was supposed to get Jaden the night of August 27th, and Mr. Brooks was supposed to send him out with a third party. There were some problems with the exchange, and the exchange ended up taking 45 minutes, and police did end up involved. Since August 27th, the parties have been following the parenting plan. We're asking the court to enter an amended temporary parenting plan, and we're asking the court to find 191 factors for domestic violence, abusive use of conflict, and withholding the child. Mr. Brooks has had a relationship with Jaden for less than a year and has blatantly withheld him 2 different times. This time in August, he went so far as to have Miss Grandchamp Brown trespassed from his property, filed a protection order against her, which included Jaden, and also blocked her number from his phone. So she really had no avenue to retrieve Jaden from him. We're asking that the court enter some restrictions, including requiring that Mr. Brooks be evaluated for domestic violence with collateral contact and start complying with treatment as recommended in that evaluation. We're asking that visitation be scaled back until that's occurred. We're also asking for appointment of a guardian ad litem and that Ms. Grandchamp Brown have sole decision making at this time period as the parties cannot work together. We're asking that visits be scaled back to every Saturday from 10 a.m. to 6 p.m. And we're asking that the parent who is picking up the child or starting their time with the child pick up the child. Currently, Ms. Grandchamp Brown is providing transportation both directions. We're also asking the court to add some more clarification around the visit exchange, as there's been a lot of conflict with the third parties that Mr. Brooks has chosen to try to send the child out with. And Mr. Brooks has gotten upset because my client was parking 3 houses down the street instead of directly in front of his house, and that was causing conflict between the parties. So we're asking for some additional orders with the parenting plan, appointment of a guardian ad litem. My client is on disability and has limited income, so we're asking her portion of the guardian ad litem fee be county paid. Lastly, we're asking the court to appoint a temporary child support order. Ms. Grandchamp Brown works 12 hours a week at the YMCA earning minimum wage. She is on disability and the hours she's allowed to work are limited. She does receive $1,218 a month in disability. Mr. Brooks is a steel worker. His income is unknown. We imputed him at $4,000 per month, but believe that he makes more than that. He has not provided any financial documentation to our office since we filed this motion. We are asking that child support begin April 1st, 2024. That is the first full month after parentage was established and the agreed parenting plan was entered. All of that results in a transfer payment of $699 a month. Thank you.
Okay, thank you. Mr. Brooks, maybe we could just start with that last item first and work our way back. As far as child support, do you have a general idea of what you're making?
I make about $1,300 every 2 weeks.
13. Are you paid hourly or salary?
Hourly,
And what are you making per hour?
19 an hour.
19 an hour. Okay. And are you average work week, you're working how much?
Minus having to deal with courts and things like that. Like my check will be pretty short this coming up, but I usually get 77 to 80 hours every 2 weeks.
Okay. All right. So about 19 an hour, 40 hours a week. So that puts you at 80 hours times 20, 60. I'm not going to do it in my head.
You're fine.
Hold on. Bear with me 1 second.
It should be somewhere around like $1,600 every 2 weeks minus their taxes or whatever that they take out for it.
Okay. Okay.
And I did quick math. It looks like he's grossing about $39,000 per year, which would be $3,293 a month. Gross.
Right. Okay. Thank you. Go ahead. And then maybe you can address the guardian ad litem. Do you have any opposition to the court appointing a guardian ad litem?
No, sir. I think that would be a good idea. I mean, I have a couple concerns as far as like the alleged me withholding our son. We had a protection order that was filed in April due to her threat herself. Just keep him. I'm not coming back for him. I had submitted text messages with the protection order, but it was denied. I checked the wrong box. I checked harassment instead of.
Your Honor, I would object. This is not an accurate recitation of what occurred in the protection order situation.
I'll allow you some rebuttal. Go ahead, Mr.
Okay,
Brooks.
I'm asking the court. I don't know the language and the lingo that needs to be spoke here in the courtroom. So I'm doing everything on my own. She's gotten free, legal assistance, and like I don't even know what to say.
Well, let me ask you. We're kind of focused on that. The guardian ad litem. You said you want one. Ms. Powers and her client want one. So I'll appoint the guardian ad litem. I'll set it at county pay for both at this point. And so the way we do that, we have the next three guardians ad litem that are listed. So each party can say, I don't want one of those. And then the other party can say, I don't want one of those. And whoever remains is the person that does it. If one party strikes one guardian ad litem and the other doesn't, then it's going to be the person at the top. And so I'll ask the clerk to read those three names, and either party can make a strike, or you don't have to make a strike.
The next three names are Ann Height, Karen Lawrence, Beth Fellows.
All right, Mr. Brooks, do you have any strikes you'd like to exercise regarding any of those to remove any?
No, I just, a guardian ad litem. I mean, I don't.
Okay.
Yeah.
No strikes. Okay. All right. Ms. Powers?
No strikes, Your Honor.
I'll appoint Ann Height, so she'll be appointed. Ms. Height will be sending out packets to each of you, and so make sure you get those and respond back to those and just be attentive to her request. So I'll appoint that. As far as timeframes, I generally go ahead and set that timeline so we can kind of keep things moving along. Let me get that order.
Another thing, Your Honor, as far as like the communication between Ms. Brown and myself, I talked in the protection order hearing about setting up our family wizard so that there would be some kind of
Means to communicate?
means to communicate, but it could also be like reviewed through the courts so that there isn't things that are inappropriate that are happening through text messages on either party.
You know how much that costs per month? A general idea?
When I was in the protection order hearing, they said something about a waiver. I would be willing to pay for half of it if she would be willing to pay for the other half. Like I don't make a lot of money either, you
Okay.
know.
Okay. Thank you. Let me just go back. We'll talk about that in just a moment. We'll give Ms. Powers an opportunity to address that, but I just want to talk about some dates for review. So I'm looking at, there's a 30-day review to make sure everybody's made contact with the guardian ad litem and everybody's exchanged information. So I'm just going to set a review for that to make sure that that does occur. Today we are the 11th of September. So I'll set a review for October 9 of this year, and that'll just be a quick check-in to make sure that everybody's communicated and there's the communication lines are open. The interim and the final review generally, Ms. Height, by chance, are you on the line? Just double checking. Sometimes they are, sometimes they're not. Generally, we look at a 3-month period, so we look at 30.
I am, Your Honor. Sorry.
Oh, hi, Ms. Height, welcome. Thanks. So I'm looking at a final report date of December 11th, but roughly 90 days from today. How does that look for your schedule and what you have in your basket?
No problem with that, Your Honor.
Okay, so we'll set that review date for the final review on December 11th, 2024. And I don't know if we necessarily need an interim review. We'll just set that initial review and then we'll have the final review. Okay, so let me just make sure I've got that, and I'm just going to finalize the payment plan here, the payment contours. Okay, thanks for your patience on that. So then, Mr. Brooks, then the next issue, we've talked about those first two items, and then the third item is there's a request to change the parenting plan from what it currently is, the Tuesday, Thursday visits 4 to 8, and then the alternating Saturday to Sunday. So do you want to address that? And if you could particularly address, there's a concern expressed by Ms. Powers and our client about domestic violence. So incorporate that into your response.
First and foremost, I've never been charged with any kind of domestic violence. Our visits for our son, she agreed when she had Miss Bliss representing her for the temporary parent visitation order that is in place, where we had both agreed on Tuesdays and Thursdays every other weekend. And she had, when I was ordered to give our son back after keeping him because I wanted him to be safe after her threatening to take her life, and for me to just keep him. This isn't the first time that she had done this. I kept my son this last time with the protection order because she had done the same thing. So that I'm asking that if I need to take an evaluation for domestic violence, that's fine. But I'm asking that Miss Brown do a mental health evaluation and that she do the same kind of domestic violence evaluation. I have no problem doing whatever the courts are asking me to do in regards to being a part of our son's life. Never tried to take him from his mom or wanted her to take him from me. It's important for both of us to be okay for him. Our differences need to be set aside. I feel like I'm being targeted as far as money and her taking time from me getting to know our son. In the first 6 months of me being a part of his life since December, I have people in the courtroom right now that could witness it. I'm a good father, and he's excited when he sees me. It's not like I'm a stranger to him, and I feel like I'm being alienated like that. Like that's picture that's trying to be painted towards me. I'm a stranger to him, like he doesn't know me.
And can I ask you, you requested that Ms. Grandchamp Brown undergo a domestic violence evaluation. Can you tell me why that would be appropriate?
We both made some inappropriate text messages towards each other.
Has there been any violence between the two of you?
No, that's why I don't understand that she's asking me for a domestic violence order. I have a criminal history, but that doesn't have anything to do with me being a father. Like, I've paid my dues to this state for my mistakes. I've done my time. Like, Your Honor, I really don't know what to say, because I feel like the things that I'm saying aren't the right things. I've been trying to find some kind of legal aid or pro bono or attorney that might be able to help me help represent me through these matters, so that certain things that might need to have been said that I didn't say. Like, I don't know if you understand what I'm trying to tell you. I don't, you know what I mean? I don't really know what to say in regards to this. I read something.
Can you tell me what the GRE program is?
What's say again?
In your submission, you said that you're living at the Oxford House and that you're participating in the GRE program. What's GRE?
Yes, sir. I'm on a GRE, which is graduated reentry.
Oh, okay.
Due to good behavior and things like that. When I was incarcerated, I was granted a program where I could get out for the last 18 months of my sentence on an ankle monitor,
right,
to help me reintegrate back into society, get a job, to become stable. I've been on it since December 3rd. I actually started it in October something. I went to inpatient treatment from incarceration as part of the program itself. I've navigated GRE with absolutely no problems.
When's your expected discharge date?
January 15th of next year.
2025.
Yes, sir.
Okay. All right. Well, thank you, Mr. Brooks. I appreciate your input. Ms. Powers, do you have any brief rebuttal?
Yeah, just briefly. In response to the information about the protection order, it was not denied because Mr. Brooks checked the wrong box. It was denied because Mr. Brooks was selective in the text messages that he provided the court. We provided additional text messages to the court, both in this action and also in the protection order action, that show that Mr. Brooks has absolutely been inappropriate in the text messages that he has sent Ms. Brooks as well. He has threatened suicide. He has threatened violence to the people around her. In our initial declaration, we talked about experiences where Mr. Brooks was physically violent with my client. There is a history of domestic violence here. And when you look at what has occurred between the withholding of the child twice, a child who is only 2 years old and has had a limited time period relationship with Mr. Brooks. And then if you also look at the pleadings in this case, the parties entered an agreed parenting plan. Ms. Bliss was representing Ms. Grandchamp Brown at that point. When Ms. Bliss withdrew from the case, Mr. Brooks filed a new parenting plan that was making him the primary parent. And then he tried to get that entered by default on 3 different occasions. Ms. Brooks has disabilities and has difficulty reading. He was taking advantage there. I assert that he was trying to take advantage of her in the court system to gain full custody. Then that didn't work. I get involved. He withholds again, files another protection order. I think there's definitely domestic violence concerns. It is true that both parties have been inappropriate in the text messages that they have sent each other. It's been a high conflict between the parties that way, and that does not serve Jaden at all, either way. Mr. Brooks does make a request about communication and switching to an app. At this point, we would ask that there be no communication right now. Right now, I am involved and there's a guardian ad litem being appointed. At least until we get the guardian ad litem report back, I would ask that there not be communication and that the parties continue to utilize a third party to walk Jaden to and from the car at exchanges so that these parties don't need to be in contact with each other. And then this is the first that I've heard about Mr. Brooks' request that my client receive evaluations. I do not think they're necessary, and I would ask that the court hold off on getting the report from the GAL before they make any rulings about whether my client needs evaluations to be completed. And then lastly, I forgot to mention, we're asking that the court pull Mr. Brooks' visitation back to just day visits on Saturdays. If the court is not inclined to do that and leaves visitation the way that they are, right now, Sunday visits end at 6 p.m., and that is in the middle of Miss Grandchamp Brown's work shift. If the court is leaving the every other weekend, we would ask that the visits end at 8:30 p.m. instead of 6 p.m. Because she's been having to change her work shifts to accommodate visit exchanges. So that would be our last request.
Okay, thank you. Mr. Brooks, any concerns about the extension to Sunday visit until 8:30 p.m.?
No, sir, as long as the visitation, stays Tuesdays, Thursdays, every other weekend.
Right.
I would also ask that the courts allow me and Miss Grandchamp Brown's, our son's grandparents to have rights to first refusal. Like if he's needed to be watched at any point in time, you know what I mean? That we have a right to be the ones that are asked first before anyone else.
Okay. All right. Thank you. Okay, so I've already appointed the guardian ad litem, and we've got those dates set. And then the next issue was the issue of child support. I think it's pretty clear what the incomes are. So I'll set the mother's income at $2,000 net per month and the father's income at $3,000 net per month. I'm not exactly sure how that comes out to, but it's going to be probably $500 to $600. I'm not exactly sure because I haven't put it in the calculator. So I think that's appropriate, and so that'll start on September 1st. Start on September 1st of this year. Then as far as the issue is adjusting the parenting plan that was issued back in March of this year, the big concern that I'm hearing is it sounds like the communication between the parties, they're struggling at this point, and there's
Yes,
been a lot of inappropriate text messages going back with a lot of harsh language being spoken to each other. The use of our family wizard, that's a tool that allows for communication to occur between the parties for the purpose of raising a child. And when parties are generally struggling with communication, having a third-party app that everybody has access to, and it generally tends to keep people on their best behavior and makes people think twice before they put something down in writing, because it's going to come to court and it's going to be seen. Obviously the parties need to do better with their communication. There's a child here, and you need to communicate for the benefit of the child. It's really, it's at this point, it's not about you, it's about the child. So I'll require that both parties sign up for our family wizard and pay their respective portions of that monthly fee. So that you'll need to take care of that. The issues of 191 factors, which are limitations, I'm going to reserve on that till we get more information from the guardian ad litem. So I'm not making a finding related to domestic violence, abusive use of conflict, nor withholding. The issue of, I'm going to require both parties to receive a mental health evaluation and follow through with any recommended treatment. There'll be additional information that comes from the guardian ad litem. As far as the domestic violence evaluation, I'm going to reserve on that and hear from the guardian ad litem to see if there's any issues related to that. The right of first refusal, I'm going to hold off on that. That very well may be a great idea, but it hasn't been fully explored. So that'll be reserved, and that can be addressed through the guardian ad litem report, and that can be raised with the party, raised with her, and she can provide that information to the court. So I don't show any at this point. I know there's concerns for withholding. Both of those instances of withholding were related to protection orders that were filed. Certainly that could be a means to exert control over the situation, or it could be a means of safeguarding a child, and the truth may be somewhere in the middle. I'm not sure. So at this point, there's been no showing any showing that there's necessarily a danger posed to the child by being in the custody of either parent. So I'm going to leave the parenting plan unchanged, except for extending the Sunday visits to 8:30 p.m. instead of 6 to accommodate Ms. Grandchamp's work schedule. So with that, that's the court's ruling. Ms. Powers, since she was the moving party, she'll draft up the proposed orders that cover those 2 items, because I've already entered the guardian ad litem report. She will send a copy to Mr. Brooks for your review, Mr. Brooks. And if you find that it's accurate and she summarized what I ordered here today appropriately or accurately, you can simply sign off on it and submit it to the court and it'll be signed off on. However, if you disagree with it, if you feel that she got it wrong in some way, shape, or form, then you can lodge that objection and we'll set a hearing, and it would be on this docket to address that. So we'll set that for the 25th of September. That's 2 weeks from today. And like I said, if the parties agree that with the proposed orders, you can simply sign off on it and the hearing would be stricken. If there is disagreement, we'll talk about it on the 25th.
Your Honor, can I get 2 clarifications?
Please.
One, is the court making any change to transportation? Right now, my client drives both directions.
Yeah, Mr. Brooks, any concerns if we would make that a little more equitable?
I'm currently on GRE. I do not have a vehicle. I could have a third party, but every time I've tried to, where she had withheld our son and I went to go and try to go and pick him up myself, I have to get it cleared through my CS3 to do so. But she tells me I can't have my current girlfriend or her mom, anybody like that, take me to go and pick up our son. So it makes conflict to where, like, she just rejects it. We don't park on her property. We can literally simply park down the street like she does at my house, and I can walk up and meet her third party to exchange my son. But I would ask that the court put in order that she can't reject the ride that I get over there. I have to have approved drivers, like they have to be approved by my CS3, stating that they can drive for me with proof of insurance, registration, and all of that. And I only have selective people that can do that for me. So like it's a process for me to be able to get somebody else just to simply be able to drive me over there.
Who are those third parties that have been approved?
My girlfriend, Brianna De Mateo.
Okay.
My friend at my house, one of my roommates, Jeremiah Pyle, but he can't always give me a ride because sometimes he works until 5 or 6 o'clock at night.
Okay.
And I mean, those are and Kelly Lynn Grandchamp Brown was an approved driver.
Okay. So yeah, I think
I mean, that's why the temporary visitation order was done the way it was done, and that she agreed to bring him to me and pick him up from my house is because of the situation that I'm in right now. I have no problem.
As far as that, I think I'm going to leave it as is. I'm not going to change the driving at this point. I'll have Ms. Grandchamp Brown. I recognize it's an imposition on her time. Having the guardian ad litem input will help as we get closer to the time where Mr. Brooks will be able to do the transportation. So we'll continue on with the way it's been.
Okay, and then Miss Brooks just brought to my attention that on Tuesday night she works at 8 p.m. Would it be possible to change the exchange to 7 p.m. so that's done before her work shift as well, especially since she's driving both directions? And I don't know what Mr. Brooks' schedule is. Perhaps his visit could start an hour earlier on Tuesdays. The Thursday visit is okay.
What's your schedule, Mr. Brooks, on Tuesday?
I work from anywhere from 5 in the morning or 7 in the morning until 3:30 in the afternoon. I have text messages in my phone where I've had my son and she's asked me to keep him until 12 o'clock midnight while she was at work. I would gladly watch our son until then instead of my time being cut short. I think that our son benefits and I benefit building my relationship with him the more time I get with him.
Okay. So
we are extending Sundays by 2 hours. So if we decrease an hour by Tuesday, he's still ahead 1 hour a week.
I mean, it's frustrating, you know what I mean? Like I see the understanding what she's saying. But in the benefit and the best interest of me building a relationship with our son, the more time I have with him, the stronger my relationship becomes with him. Yes, I've only been a part of his life since December, but I'm trying to build a relationship with him, not have time taken away or extended by 1 hour or whatever to accommodate somebody so that they can go to work. Like that's, the time that I get with our son, that's the time that I get. So I'm just asking, if if need be, because I would watch him until 12 o'clock like I have in the past for her while she was at work.
Okay. All right. Thanks. Parenting plans are always difficult because there's always there's lots of moving parts and lots of obligations that each of the parties have. So the Saturday 10 a.m. to Sunday at 8:30 p.m. that happens on an alternating week basis. So that's the change there is a net of about 4 hours per month. The Thursday visit remains unchanged, the 4 to 8. And at least with the current schedule, I'll adjust the Tuesday night, so it's 4 to 7. I recognize that's a decrease of time. That's probably frustrating, but I'll grant that at this time. Okay, so with that, we've got a plan to come back on the 25th if necessary. So thanks everybody for your input.
Okay, so the 25th of this month then is our next board. Is that
That's
9
9
a.m.
a.m.
docket?
Yep, 9 a.m.
Thank you.
Yep. Okay, all right, thank you.
And one last question, the court entered the GAL order. I don't need to draft that, correct?
Correct, I took care of that.
Thank you.
Yes. All right, thanks.
Yep, thank you.
All right, very good. Okay, so we're here in the Joanna Smiley and Robert Smiley matter, 21-3-00458-0. Please take a seat. I'll ask if Joanna Smiley is present. That's you? Okay, great. All right, and I'm assuming you're Mr. Robert Smiley, correct? You're Robert Smiley?
Yes, Your Honor.
Okay. And Mr. Adagnostou, do you need the hearing devices?
Oh.
Do you need the hearing device? Do you need?
I'm okay.
Okay, great.
I have a notice of appearance. I spoke with Ms. Smiley yesterday and told her I'd be appearing and sent it to her by email.
Okay, is that accurate? Okay. Okay, so we're here today on Mr. Smiley's motion for contempt. And I checked the file to make sure that Ms. Smiley, you received the documents that he's talking about, the motion for contempt, the order to come to court, and his declaration. You received all that?
Yes.
Okay. All right. So we're talking about an underlying parenting plan order from May of 2023. And there's concerns related to parenting plan violations, unpaid judgment, and a concern related to not exercising parenting plan time allotted. And then I wanted to check with you, Ms. Smiley, if you, sometimes people will write down their response to whatever the other party said, and they'll write it down, they'll file it with the court, and then send a copy to the other side. And when reviewing the file, when did you file that information?
Yesterday.
Okay. That's okay. That's good to know, because when I reviewed the file last night, I put Ms. Smiley's input and I said none, because it's not instantaneous, just so you're aware. So it gets filed. There's a processing time that's required 2-3 days, and then it hits my file. Okay. And so I haven't read what you want me to know. And did you serve a copy on Mr. Adagnostou?
I did not. I have
Okay.
a copy of it.
Okay. Yeah. So Mr. Adagnostou will need a copy of that, of what you've said. So I think at this point, with the late reply, I'm inclined to continue the matter so I can read what you have to say in response to what Mr. Smiley has said. Mr. Adagnostou?
Yes, Your Honor. The primary issue with the continuance is children have been taken out of their school. Okay. And they need to get back into their school. My client has talked with Castle Rock, and they're waiting, willing, able to get the children back in school. Currently, they've missed 1 week, and they need to go back to school. Castle Rock is, we're talking about 2 children, Tatiana, who's 11, and Jackson, who's 9. They've only gone to Castle Rock. And
your client still lives there in Castle Rock?
Well, no, he doesn't live in Castle Rock, but he actually lives in Winlock, but he's made arrangements, and we'll make sure that they can get to Castle Rock every day.
And is that so does there need to be some type of waiver or from one district to another, based on residence? Because it sounds like she's in Ms. Smiley's in Clatskanie.
Yeah, she's in Clatskanie. And Castle Rock didn't indicate there was any issue with the children going back to school, back into their grade at Castle Rock.
And do they know that Mr. Smiley lives in Winlock?
Yes.
Okay. Okay.
And that
And Mr. Anagnostou, to your knowledge, did your client receive any type of notice regarding a move to Klatskanai?
No. No, we're looking at, it's paragraph 13 in the parenting plan, which sets out all the things that Ms. Smiley was supposed to do in order to relocate the children. And she hasn't followed the relocation provisions in the parenting plan. Haven't given an opportunity for my client. You know, there's a 60-day notice that she has to provide.
Okay. Thank you.
And so our only concern is on a continuance that the children are not back in their school. They need to be back in the school that they've only gone to. And then while we get this, if, you know, Ms. Smiley is going to continue to go forward with a relocation, I assume, I mean, there's a 60-day notice, you object to it. The court generally appoints a guardian ad litem to do an investigation. But going through this process, the children need to be in the school that they've always gone to.
All right, thank you. All right, Ms. Smiley, the issue is whether we continue the case a week so I can read what you have to say, or based on Mr. Anagnostou's representation, whether there's some type of interim decision today and then come back and have a more full hearing. And the interim hearing today relates to whether the children should be attending Castle Rock schools or attending in apparently Klatskanai. So the floor is yours.
Yeah, I would like a continuance so you can read what I have to write, what I had to say. We did give them notice on 7/19 when we were exchanging children, when he threw my mail in my face. We didn't.
Was it written or
technically-
verbal notice?
It was verbal.
Okay, go ahead.
We didn't technically move to where we are now and until 3 weeks ago, because we couldn't move into my boyfriend's home. He wasn't allowed to have any other people living there. So he moved also. So we just moved 3 weeks ago, basically, to where we are now.
So the request that Mr. Anagnostou said is his request on behalf of his client is, let's kind of pause things, have the children attend Castle Rock where they've attended previously until we kind of figure out what the next steps are, having heard what you have to say, and then and see whether or not the relocation was proper or not proper. But in the interim, tell me what your thoughts are about where the children should go to school in the interim until we come back.
They are currently enrolled in Klatskanai schools. Last I knew, in Castle Rock, you actually had to live in Castle Rock to actually be able to go to those schools. He lives in Winlock. I live in Klatskanai. So there's, I mean, I don't understand how that would work out.
What's the distance between Klatskanai and Castle Rock driving time?
About 45 minutes.
One way?
One way.
And if I were to enter an interim order that would require the children to attend in Castle Rock, are you able to transport the children so they get to school in time and still meet your other obligations, work and otherwise?
No, I have to be to work at 7 every morning.
Okay. Do you have any individuals that could support in getting the children to school?
No, my boyfriend has to be to work by 6. And I don't really have anybody else there that can do so.
Okay. When did school start in Klatskanai?
On the 5th.
And when did school start in Castle Rock? Do you know?
It was the 3rd, Your Honor.
3rd? Okay. 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 So for today, since I know what Mr. Smiley wants, I've read his perspective, and I don't really know Ms. Smiley's perspective. The children have been attending school since it sounds like the 5th of September. Looking at the calendar, that's last Thursday. So they've been in school 1, 2, 3, 4, 5 days today, 6, 7, 8, 9, 10 days when we would come back next week. Certainly that's not it's not good for children to be flip-flopped with schooling and education, and especially during the first part of the year. That's really kind of key, where kids get their feet underneath them and have that stability moving forward. Concerns are that there's a clear indication in the parenting plan order from May of 2023 that gives guidance of what you need to do when you want to relocate. And it's very specific, and it actually takes up a lot of the parenting plan order. and there's indications that it was not followed. There's indication there was some verbal notice, but not the required written notice. So those are concerns. There's some concerns related to that Ms. Smiley raises, whether the children can attend Castle Rock schools while father lives in Winlock. Father indicates that the kids can. He's had assurances the Castle Rock said they can attend there in that particular school. I'm going to grant a 1-week continuance. The children will continue where they're at. We'll come back next week, and the outcome may be that the children go to Castle Rock. So there should be provision made ready for that, and there should be so all options are on the table when we come back next week.
I understand court's order. There is one issue I'd like to present to the court.
Okay.
My client was supposed to have last Wednesday, and he had been overnight on the Wednesday. That didn't happen. It's my understanding that Ms. Smiley got the days mixed up. But anyway, can he have this Wednesday today for his missed visit of last week?
Ms. Smiley?
The school visitation time is when school starts, not before it. So they started on the 5th, which was a Thursday. So in the parenting plan, it starts when school starts, so it would be the next Wednesday after.
So, no, is your answer?
You know, I'm not one to keep his children from him. If he would like to have his children today, that would be fine with me. But they would need to be back to school the next morning or on Thursday, you know, by 8:15.
Okay. If the party's in agreement with that, then you can work with that agreement. Okay. See everybody next week. Great. Okay, so a lot's gone into the, I've addressed a couple of different cases, and so you're gonna have to remind me where we're at, where we left off and why we took the break that we did.
The guardian.
Thank you. Ms. Corey, are you on the line?
I am, and my apologies, Your Honor.
It's all right. Glad you're here. Thank you. So I had noted today was an interim review, and prior to you coming on, Ms. Corey, when I initially spoke with the parties, Mr. Cox and Ms. Peters, they indicated that it's likely today's effort was going to be focused on whether or not they had made contact with you. They both assured that they had made contact, and that we've had a final review in November. And there may have been something else that we talked about, but I'm not sure. Mr. Cox, do you remember?
About getting temporary custody.
Okay.
For at least visitations.
That's right. And that was going to be part of the review today. Okay. So that's kind of where we're at. So Ms. Corey, do you want to just kind of chime in and just give a status update?
So I was assigned this case either July 31st, I believe. So I've only had it about 40 days now, and I have received intakes from both parties. I have met with both parties and done a home visit with Ms. Peters. And from what I have reviewed, so they are in compliance. I mean, I wasn't entirely sure whether this was a compliance hearing or whether you wanted more. I have requested CPS records, have not, of course, yet received those. Those are usually about 45 to 60 days out. But from what I've reviewed so far, I do need some further information, and I could get that information. I'd like to see Mr. Cox do a SUD evaluation and a domestic violence evaluation, and I would like to see Ms. Peters do a mental health evaluation. This would give me better information to proceed to that final review. Also, the court asked, and I believe Mr. Ruff, who is Ms. Peters' significant other, is required to not be alone with a child who is not his biological child. And I would like to see maybe the court actually order that so that it's in writing, if that's.
Was that included in any type of prior order or verbal or otherwise?
I'm not sure.
It's not, it wasn't written up. It's because he is a sex offender. So it's what we were told by the police department.
Okay.
Is what he's not allowed to be left alone with any children that are not biological children.
Thanks. All right, and then Ms. Coy, Mr. Cox raised an issue. It sounded like he was he was under the impression that there was going to be a potential adjustment with the visitation schedule. Do you have any comment on that?
I do not. It is way too early in the investigation to make that determination.
Okay.
And I don't have the information that I need yet.
Right. And is there a stopgap parenting plan in place right now? Mr. Cox, I'm looking at you. Just kind of, is there any type of guidance as far as parenting plans?
I mean, I submitted.
Right. Yeah, I see some proposed orders, but is there anything that the court's ordered and said, hey, this is what the parenting plan is going to be? Not at the moment. Okay. Ms. Peters, do you agree with that?
Yes, there is nothing in place at the moment.
I would like to be able to see my son at least have some sort of visitation.
So right now there's no visitation in place.
No.
That's also because there is a protection order in place covering myself and our child.
Is that accurate, Mr. Cox? That's in place. Okay. All right. Thank you. Okay. Let me just ask, Mr. Cox, you heard the guardian ad litem indicate that what would help her in her investigation to gather more information is if Ms. Peters did a mental health evaluation that you did, and that you did a DV or domestic violence and a substance use disorder evaluations. Do you have any concerns about that?
I'll do both of those.
Okay. And Ms. Peters, do you have any concerns if that was required of you?
No concerns.
Okay. So I'll require that. And then Ms. Corey, do you have information where they each can go to get those evaluations completed?
I could possibly assist with that if they can't find that.
Okay.
I believe Ms. Peters might already have the availability of doing that through Columbia Wellness.
Okay.
Yes.
Okay. All right. So Ms. Peters, you can check with Columbia Wellness and get that taken care of. And then Mr. Cox, if you need assistance you can look on your own to find locations that can provide those two services.
So it's domestic violence and drug and alcohol.
Right. Yep. So, and if you need any assistance with that, then you can check with Ms. Corey and she may have some ideas or options for you.
Okay.
But you're certainly to look on your own.
I would recommend Olivia Lovely for the domestic violence evaluation.
Okay. Okay. Cool. All right. Very good. So then the next request was from Ms. Corey related to Ms. Peters' significant other, that restriction be put in writing, that he not be alone with the child of these two parties. Ms. Peters, do you have any concern with that restriction?
It's also part of his current registration at the moment as well.
So no concerns if the court were to order that?
No concerns.
I'll do a handwritten bench order at this point in time. And Ms. Peters or Ms. Corey, can you tell me the name of the significant other?
Terry.
Terry, Terry, Ruff, Ruff.
And there's just one child between Mr. Cox and Ms. Peters.
Yes.
Okay, so I put that into writing. It says Terry Ruff shall never be alone with the party's minor child. Hey, Ms. Corey, do you think that's sufficient?
I think so.
Okay, so I've signed off on that and note that both parties are present. There was a request by Mr. Cox to allow some visitation. The complicating factor, it sounds like, is that there's a protection order that not only protects or restrains him from having contact with Ms. Peters, but also the child apparently is included within that. Yeah. And is that a anti-harassment order or a
domestic violence protection order?
Okay, how long has that been in place?
It was granted this last December.
December. Okay. So at this point, I'm going to hold off on making any changes to the visitation plan that's apparently not in place at this time. So I'm going to hold off on that till we get more input from the guardian ad litem. Okay, with that, let me touch base with Ms. Corey. Do you have any additional items you want to share or requests or anything?
No, I don't. Thank you.
Okay, Mr. Cox, do you have any additional items? Okay, thank you for being here today. Ms. Peters, do you have any additional items?
I did have a question.
Okay.
For both of our treatments, are we turning the documentation for that into the court or to Miss Corey?
Yes, both.
Both? All right.
Right, so you share a copy, Ms. Corey?
Can you include in that order, Your Honor, any treatment that comes from those evaluations that they also comply with that? Any recommendations of treatment?
Yeah, sure. Maybe I could just do that on the handwritten order. I'll just include that therein.
Thank you.
Right. Thanks for your patience. The rest of that order states petitioner, meaning Mr. Cox, shall undergo a substance use disorder and domestic violence evaluations. Respondent, Ms. Peters, shall undergo a mental health evaluation. Collateral input from both parties and the guardian ad litem shall occur. Any recommended treatment shall be engaged in and completed. So I've signed up on that. That'll complete our efforts for today. Thanks for being here today.
I also had one more quick question.
Go ahead, Ms. Peters.
Because of the fact my other half, Terry, is living in the household with my Anthony's child, does he need to do any mental evaluation as well? Or no?
At this point, there's been no.
Ask if that's possible for that to happen.
What type of evaluation are you asking for?
He has very aggressive tendencies, and I just feel a little better knowing that he got that checked out.
Ms. Corey?
Well, because I really did not take a look at that because he is not a party to the case.
Okay, so
I'm not sure.
Okay, so I think what we'll do, I'll reserve on that, and if Ms. Corey in the future feels that that's necessary, she can bring that up and bring it to the court's attention. Or you, Mr. Cox, can make a formal petition and kind of provide some support and rationale why that should occur. So it's reserved, it's not denied nor granted, but it's reserved, and any party can readdress it. All right, that'll conclude the hearing for today. Thank you.
Thank you.
All right, thank you.
Is there going to be another court date scheduled?
I think Mr. Cox's question was, is there going to be another court case date scheduled? And I think that we talked about in the guardian ad litem report, there's a date for a final report that's set. Yeah, whenever that's set in the guardian, I'll just pull it up here. In the order appointing, it sets a date of. Ms. Corey, is there? Oh, there it is. November 20th.
November. All right.
November 20.
20.
Yep. Okay. All right. Thanks. Okay. No response from Ms. Chapman.
I'm
Bryce?
here. I'm sorry. I couldn't get my phone to unmute.
Okay. Ms. Chapman's present. If you'll turn on your video, please. Okay. Thank you, Ms. Chapman. Then Bryce Chapman, are you on the line? Bryce Chapman?
He is not. I did not I couldn't find him to see him and do that, but I also just got back from the courthouse to pick up even more stuff that is just came about.
Okay. So as far as Mr. Chapman's present, Ms. Chapman, did you serve him with copies of the documents and then submit a declaration of service indicating that he had been served?
I have not been able to serve him because he won't communicate and I don't know where he is.
Okay.
I see him on Friday and I'm hoping to have this huge stack of other stuff filed before then.
All right.
There's a lot of safety issues that my children brought to me.
Yeah, so any of the concerns that are in your motion for contempt, we won't discuss those specifically here today, just simply because there's been no proof of service that he has been served. And so what will need to happen is that you'll need to get if you think you can serve him by a certain date and then set it for a hearing. Sometimes people will serve the person and then give them a notice of a date later. So generally what needs to happen needs to be, generally it needs to be 3 weeks in advance.
Yeah.
So if you can go ahead and serve, and then you'll have to re-note it up for a hearing. So once you get that service, it can be Okay.
I thought I was going to see him and then he avoided me. So So that's what this problem is. But do you think I can make the court date the same for the papers I'm filing right now as well as those ones?
Okay, Ms. Chapman, it looks like I froze there for a bit and you froze also. So the next step would be you'd need to serve Mr. Chapman with your documents related to the motion for contempt, and then give him a docket notice, and then have it set for a particular date when you serve him, so he knows what date to come to court. And so
Okay.
that's the next step. So we won't.
So then the papers I'm filing this week it's so much stuff. Do you think they'll be able to do the same court date for both of those?
They potentially could. It depends on the date that you choose to have them come to court on the contempt, and if you align that with the other matter, then potentially they could be on the same dates or they could be on different dates.
Okay. Okay, they're set to go with them on Friday, but there's a huge safety thing, so I'm trying to get all of this done, and I don't know. Okay.
Okay. All right.
All right. Thank you.
And take care of that service issue, and then once you've got that served and noted, we can hear it on the docket.
Okay. Thank you.
Okay. Thanks. Cameron Miller is present. And Mr. Jensen, I'm going to call your case after this one. Perfect. Thanks. All right. Hi, are you Taylor Young? Okay. Welcome, Ms. Young. And I'll ask if Cameron Miller is on the line. Cameron Miller. All right, Mr. Miller, if you are speaking, I cannot hear you, so make sure that you're unmuted and state your name. I'm going to take a look at the participant list. I'm not hearing anybody speaking, so I'm just going to look under his name. Not seeing anybody in the K's, and I'm looking in the M's, not seeing anybody there either.
In jail.
He's incarcerated. When was he arrested? On Friday. Okay. And then it looks like you received notice of today's hearing.
Yes, I got a I was served with a restraining order, but not contempt, but the restraining order had the same day.
Okay.
But I didn't get a chance to file this. I had court as well, and I had a protection order, and he didn't go to court then either, so they granted it to me for a year because right now we're in a case of sexual abuse.
So you have an existing order that restrains him from contacting you, is that correct?
Yes, for your and my child.
Okay. All right.
And I have it right here too. It was just finalized on.
Okay. All right. Thanks. And then and are you up in Centralia? Is that where your home is? Okay. And then you said you were served on Friday, right? So so I'm curious about you're here today.
Oh, I was served by Officer Croy. I don't remember exactly what day it was. And then I served him, and he didn't get served until he was put in jail because he was avoiding it.
So your general time frame when you were served is what? When we were served, roughly? Week and a half ago. Okay. All right.
I also didn't know how that worked with him having a restraining order, but I already had a protection order, and it protected Malaya from him.
Yeah, sometimes there's competing protection orders, and both parties can be restrained, in different types of cases. So that's not unheard of. He's not present. You've indicated that he's incarcerated still, and he's in Cowlitz County. Is that correct?
He's in Thurston.
He's in Thurston. Okay. Madam Clerk, do you know if there's been any requests from Mr. Miller to appear via Zoom? Okay. I'm going to double check in my email to see if he had made a request of maybe my assistant or what have you to appear via Zoom. Okay. I haven't received any notice that he had made that request. So let me just take a quick look at his motion again, just one moment. Okay, I think what I'll do, he's not present today, so I'll deny the restraining order, and it can be brought back again once he's present if he wants to. But at this point, I'm going to deny it. So I think I was given a proposed order. So let me just see if it's here. And we'll just indicate that it's denied. Madam Clerk, just confirming with you, Mr. Miller prepared a proposed order but I'm denying it. Is there a separate denial order that I should sign, or just simply put an X through it all and say denied? Yeah, I'll do that.
Your Honor, so aside from the parenting plan, if this shows that I have full rights to her on this paperwork, does that override, since it now has jurisdiction over the parenting plan, or is that the last time if he gets out, he's still able to just take it because?
As a general rule, and this doesn't hold true always, but as a general rule, when there's restraining orders that are in place that are, say, just a general civil restraining order, generally those will give way to a family law order. So generally the idea is that if the family court makes a parenting plan order, then that would control and would control over the restraining order. There still may be those restraint provisions, that those are still there, but the court generally can enter in and carve out a parenting plan that the parties would need to abide by.
So could we do since he is incarcerated and he isn't getting out anytime soon, can we make it to where I do have custody for her at this moment?
Not without notice to him.
He has notice from this, you got served in jail too.
Do we have a hearing set for today for him that you gave notice of?
No, he's in jail. The sheriffs and stuff are serving him there.
Right. So the idea is that there needs to be due process for both parties. So if you're asking for new relief or asking for something new and he doesn't know about it, it would be improper for me to grant that here today because he doesn't know anything about it.
But he knows about it. That says it in the protection order.
Yeah, you said the protection order has been entered, so that order is valid, but you're asking me to take an additional step, it sounds like. Is that true or not true?
Yes, about the parenting.
Right. And did you give him notice that you wanted to talk about that today?
No, I wasn't able to.
Right. So that's why we won't talk about it today, because that's the due process. Each party has to have notice and an opportunity to be heard. So he hasn't been given any notice about what your request is, hasn't been given an opportunity to be heard on the issue. So I'm denying that request. You have any questions?
So do I just go file a change of parenting plan and come out here?
That's an option. If you'd like to do that, you'd have to give him notice and he'd have an opportunity to respond and have an opportunity to participate in the hearing. So if you want to do that, that's fine. You could do that too.
Okay, but I'm not in contempt, correct?
There was no motion for contempt here today. There was a request by Mr. Miller for a restraint order to be imposed. He's not present, and so I denied his request.
Okay, thank you. The clerk just said it was working.
Mr. Johnson's present in the courtroom. Welcome to you, sir.
Thank you.
And then
All right.
Shannon Kelly Johnson, are you on the line? All right, Shannon Kelly Johnson, if you're on the line, please make sure you're unmuted and state your name. Looking under, so there's no response. I'm looking under the participant list for a Shannon or a Kelly or Johnson. Okay, I'm not seeing her located in there. So let's take a look. This is Mr. Johnson, your motion for contempt. And we came here, I think it was on the 29th of August. There was insufficient time. There wasn't 21 days. And at that time, Ms. Kelly Johnson asked for 2 weeks. So from the 29th, that put us to today's date, the 11th. And have you had any contact with Ms. Kelly Johnson?
Just my service person did. And
okay. But today, as far as her whereabouts?
No, I haven't.
Okay. And Madam Clerk, any communication that your office has received as to maybe she's got waylaid or okay, clerk indicates no indication there. And I'll just double check again. I'll just look at the file to make sure that there were if she had filed anything in response. She didn't. Did you receive anything from her and filed in response? Okay. So let me just clarify this because there were some parties that I wasn't quite sure. So there's these messages that came through Facebook Messenger, and it came from Ms. Kelly Johnson. Then it was sent to Mike Wojcik.
I believe so. Yes.
Okay, and then those are forwarded to Rianne Wojcik, who is the babysitter.
Correct.
And then that in turn was forwarded to you.
Correct.
Okay, and the order we're talking about in April of this year says both parties are strictly prohibited from any disparagement of the other parent, no matter its form, content, or setting. And so on August 9th, I'll read this and make sure I'm getting the parties correct because I wasn't exactly sure, but I think I pieced it together. It said, that, and I'll say Mr. Johnson, it didn't say that in the text, it says Mr. Johnson beat the heck out of Ms. Kelly Johnson last year. It took over 2 months for injuries to heal. Did I interpret that correctly?
Yes.
And that it says your daughter, meaning Rianne Wojcik's daughter, has served me all of Mr. Johnson's paperwork?
Yeah, Brianne is my service
Person.
for, yeah.
Okay. All right. So this text message comes from Ms. Kelly Johnson to
Brianne's father.
who is Mike,
Correct.
and says has served me all of Mr. Johnson's paperwork. Okay. Then it says she is head over heels for a wife beater. I'm not sure who she is.
Brianne.
And Rayanne, and is that in relationship to you as being called a wife beater?
Correct.
Okay. All right. And then it says, I just called the cops on Mr. Johnson because Xavier pulls out guns when all the kids are alone. Who's Xavier?
Xavier is my well, he just turned 18, but he's my son.
Xavier.
He was
Okay.
a minor at the time.
Okay. All right. And then it says, I heard Rianne moved into that house. Good luck to her. Hopefully Xavier doesn't kill her. And those are the messages that you're concerned of.
Yes.
Okay. All right, thank you for reviewing that with me. Again, I'll call out if Shannon Kelly Johnson, are you on the line? Or there's no response, I'll grant the contempt. Just give me one moment. Did you have any fees or costs related to this motion, Mr. Johnson?
No.
Okay. Mr. Johnson, just I could look this up, but I'll ask you, has Ms. Kelly Johnson been held in contempt previously?
No.
All right. Thank you. And you in your proposed order, you indicated that you're requesting a review of the case in December. Tell me the purpose of that hearing.
That's for my domestic violence protection order review.
Okay, so that's already been previously scheduled.
Yeah, it was continued, but yes.
Okay, so it's to that date. Okay. Thank you. One last item here. Okay, so I'm granting the motion for contempt. I'm imposing a $100 civil penalty upon Ms. Shannon Kelly Johnson. I noted in the order that I don't know if she has the ability to follow the order. I put unknown, petitioner failed to appear at the hearing and did not submit any written inputs. I made a finding that she's in contempt. I struck the portion about the jail time. I struck that. It's her first contempt. I indicated that she can purge the contempt if she continues and completes her anchor management course, shows signs of improvement and compliance in order of disparagement. And I struck the date for a review. So I signed off on that. Do you have any questions?
I wasn't sure if I put it in this one for a GAL. Is that in this motion or is that for the?
That would be a separate motion that you could submit a motion for appointment of a guardian ad litem. And so let me just double check in your motion for contempt. Is that something you included therein?
It was either that.
Yeah, you did. Yeah, it was in your motion, appointment of a guardian ad litem for Viridian.
And then a reduction of.
And supervised visits and reunification until the GIL assessment. So the issue is that so the motion is for contempt hearing, right? So that's kind of the big bold letters on the front page, and then on the last page in really small font, it says, and I want a guardian ad litem, and change the parenting plan and stuff. Not to say you're being sneaky or anything like that, but it's to the uninitiated with legal stuff. When somebody reads motion for contempt hearing, that's kind of what they're thinking. And they're not thinking, hey, this is a motion for a guardian ad litem. Hey, this is a motion for adjustment of a parenting plan. So those issues, if they're of importance to you or you still want to pursue those, you need to file those separately. So
Okay.
there's forms. If you go to the web page with the different forms, you can find the forms related to the motion for appointment of guardian ad litem, and you can find a motion for adjustment of a parenting plan or yeah.
Okay.
Okay. Any other questions?
No.
Okay. All right. Thank you. Looks like Mr. Sasaki is present. I can see he turned his camera on, so I'm assuming you can hear me.
Yes, good afternoon, Your Honor. Representing Martin Daniel Perez, the father.
Okay, very good. And then I see Mr. Zandy's present. And Mr. Zandy, can you hear me all right?
Loud and clear, Judge. Thank you.
Great. Right, and Mr. Zandy, you're representing Joel Perez, and I see Ms. Perez is present, and Mr. Perez are both on the line now.
Correct.
All right, so this relates to, I believe, Ms., pardon me. This relates to Mr. Perez's motion for a temporary order related to parenting plan and also child support. I read the pleadings by the parties, so I'll hear from Mr. Sasaki first, and then we'll hear from Mr. Zandi. Mr. Sasaki?
Thank you, Your Honor. Just a brief rundown of what brings us here today. Mr. and Ms. Perez have been married since 2013. Ms. Perez filed for divorce February of this year. There currently is no temporary parenting plan. That's the reason for our filing of this motion. However, in February of this year, Ms. Perez did, however, file a proposed parenting plan with no limitations and no limited decision-making as to Mr. Perez's parenting. So today, we respectfully ask the court to approve the parenting plan proposed by Mr. Perez, which reflects the status quo as we work with Ms. Perez through her counsel, Mr. Zandi, to finalize the divorce. The parenting plan includes not taking the daughter, Addison, age 7, out of state, and again, preserving the status quo and the child's strong relationship with both parents. Responding to Ms. Perez's second proposed parenting plan in order, as to the responsive child abuse allegations, the current investigation is ongoing, continued until the end of this year, December 6th, and likely to be continued again. As to previous accusations, Ms. Perez corroborated Mr. Perez's innocence. The matter was dismissed, and DCYF's investigation concluded that the action was unfounded. As to the responsive claim of abusive use of conflict, I do not see any history of fostering of conflict that disrupts the legal process or exhausts the other party. As to the responsive request for a substance abuse evaluation, my client does not have an issue with substances and has refrained from all alcohol since August 31st of this year. Regarding the responsive proposal of limitations to be imposed on Mr. Perez, as to the proposed supervised visitation, there have never been any allegations of Mr. Perez abusing his own daughter. As to the proposed psychosexual evaluation, there are no grounds for that. I don't believe there's even a basis for a mental health evaluation. Once again, Mr. Perez has never been convicted or pleaded guilty to any sexual abuse. As to the proposed domestic violence evaluation, the property damage incident was an isolated incident. My client acknowledges that, and that has been more than 10 months ago. As to the limited decision-making, there is no significant evidence to change Mr. Perez's decision-making abilities as to his own daughter. So in closing, we respectfully ask the court to approve the proposed parenting plan for Mr. Perez, which again helps to maintain the status quo and preserve the child's relationship with both parents. Thank you.
Thank you. And just so I'm clear, Mr. Sasaki, Mr. Perez's proposed order would be the Monday morning to Wednesday morning and then alternating Saturday to Wednesday. Oh, Mr. Sasaki, I apologize. It looks like you've been muted.
I apologize. Our parenting plan has the father with the child every Monday, 7:30 a.m. through Wednesday, 9 a.m., and every other Saturday, 9 a.m. to Wednesday morning, and drop off at school, or 9 a.m. on a non-school day. And on Thursday mornings, when mother works, father would pick up the child at 6:30 a.m. and return to mother after work.
And that's on every Thursday, right? Related?
Yes, I believe so.
Okay. All right. Okay. Thank you. And then as far as financials, do you want to just address that?
Yes, as to financials, my client is new as new employer, and it took him a while to get up to 40 hours as indicated in the declarations. And so I don't believe that it's appropriate to impute a higher income to him based on historical income, based on the circumstances. His income may go up, but under the circumstances, he's in a new job, and the realities are that his income is a lot lower than it used to be.
Okay. All right. Thank you. And then before I turn the time to Mr. Zandi, I just want to double check, and maybe your client can assist. Tyler Murphy, I understand that's a significant other of your client. I know a Tyler Murphy, no, or shaking head no, or?
It's not, that was the allegation. That's who he thought she was having an affair with. I don't think there's been any information of that. It's a long-term friend who she was texting. That's about the extent of it. So there's no relationship to the best of my information. Correct, Joel?
Correct.
Okay, the reason I raise it, I know a Tyler Murphy, and is he about 6'4", really well built, really big guy, and loves to deer hunt?
No.
Okay, so it's a different Tyler Murphy that I know. Thanks.
Yeah.
All right. Mr. Zandy.
Thank you, Your Honors. The court is aware I do represent the petitioner and non-moving party to the motion before you today, Joel Perez. And what strikes me out of the gate is the amount of minimization on behalf of the dad to assure this court, again under the penalty of perjury, that everything is fine and dandy and well, when the reality is starkly different. This is an individual right now who, again, and we certainly stipulate he has a relationship with his daughter. My client tells you, by my count, 2 or 3 different times in her declaration, she wants to preserve that. But this is not about what's best for dad. This is not about what's best for mom. This is ensuring the safety and well-being of a 7-year-old child who deserves to be well-maintained and well cared for in both parties' homes. The reality is right now we've got significant concern about Mr. Perez, and we have zero accountability on his side pertaining to all the issues. This goes beyond the sex offenses. And again, these are not just could be, might happenstance type of cases. These are ones where he's facing multiple felonies for serious violations while he was employed by the government. He was entrusted to care for these kids. He was entrusted to make sure that they were safe, make sure that they were sound, and we have this allegation. In response to that, again, this is part of the minimization. In response to that, he doesn't say, yes, it happened, or no, it didn't happen. He says, to my client, they can't prove anything. And again, I was somewhat surprised on the reply from Mr. Perez that he doesn't take a real strong position one way or the other. And I certainly understand that this is a pending criminal matter, so his ability to speak about those instances are somewhat limited. But nonetheless, you would think that someone to their wife, this long of duration would come out and adamantly deny that that ever happened, and instead not say, well, they can't prove anything. This is also on the heels of another subsequent investigation to that, where again, he was entrusted with the care of a young child, 11 years old at the time, who he's providing foster care support for, who again makes similar allegations. He's charged with that. Where there's smoke, there's usually fire, and I hope I'm wrong, and I hope that none of this happened, but it is beyond me how somebody who has already faced that allegation in very recent history proceeds to put himself in a situation later on, again, under the cover of his employer, which is exceptionally problematic. Again, an employer through the state who entrusts its caseworkers to provide support and safety for these kids who life has already dealt them a difficult hand. To subject them to this type of behavior. We've given you examples of that. We've given you reports that have been furnished. Again, we won't know exactly what the outcome is until the time of trial, but this court needs to err on the side of caution and safety and the well-being of this child. And certainly this child's best interest is not being put in the lion's mouth, and hopefully nothing happens to her. This is absolutely a case that requires a psychosexual evaluation. This is one that certainly merits and warrants that. Given the circumstances and how we find ourselves here today. And this is one where I would suggest, and again, my client has been extremely, I would say, overly reasonable with her visitations with Mr. Perez. This is one where until we have the answers to that, I'm not sure Mr. Perez should really have any visitation at all pending a GAL investigation, pending a lot of these questions that can be answered. The only way to do that is through the criminal action, do these evaluations as we suggested, and through some time to make sure that the GAL has adequate information to approach this subject and do due diligence in the investigation. My client,
Mr. Zandy, when the criminal allegations were filed?
I'm sorry?
The date the criminal allegations were filed?
I don't know specifically. I think it was around the same time these parties separated. My client became aware of it, I believe, at the end of the year of 2023. They started making plans to separate, and I believe again, that would be a question for Mr. Sasaki, but I believe it was sometime around February or March of 2024.
Mr. Sasaki, do you know precisely?
I apologize, Your Honor. I do not readily have that information. My client, Mr. Perez, may be able to advise as to that date.
Mr. Perez, could you just chime in on that briefly?
Yes, Your Honor. So if I recall correctly, information was filed on January 5 or around that time of this year. However, first contact was made with me in May of last year, at which time I did inform Ms. Perez of the allegations and adamantly denied it, contrary to counsel's recitation.
You're going to object to any information outside of the direct question.
Okay, thank you, Mr. Zandi. Go ahead, please.
So in any event, if we look at the totality of these circumstances, very alarming. If you look at the submissions that we have given you, again, you've got an individual who's being charged with not only taking indecent liberties with a young lady who at the time was 14, but also creating social media accounts so he can communicate with this person, telling her that he's going to marry her when she turns 18. Informing her again of showing her graphic pictures. Again, these are all the allegations that need to be overcome at the time of trial. And if you look at that and circumvent from what happened prior to that with this foster care child who's reporting very similar instances, again, she was 11 at the time, very concerning. He's had 2 criminal investigations. The first one, due to the lapse of time and insufficient evidence, which is not uncommon, as the court is aware in these types of sex cases, it went by the wayside. Rather than changing the conduct, rather than acknowledging the problem, Mr. Perez doubles down and takes even more violent actions against the 14-year-old, again, who he's transporting, getting her coffee between Battleground and I believe it was somewhere closer to Mount St. Helens. Nonetheless, he's doing these types of things, and the information is staggering. And again, I mind you, that's concerning enough. This case doesn't just revolve around that issue. There's the domestic violence component of this. Again, my client has given you information that's very specific. I was somewhat struck, and again, this is more minimization, in which Mr. Perez details it as well. There was an incident. There was an incident, and it was extremely significant, and it was less than 10 months old, and it was right directly in front of the child. My client details for you that she gets home. Mr. Perez has been drinking. Again, I think we've confirmed that with the messages that we provided for you. He's drinking, he's out of control, he's got control of the child. My client, recognizing him when he's been drinking, gets somewhat hostile, somewhat verbally combative. My client takes the child to get away from that, as we would hope that parents would do, goes to the master bedroom, locks herself in there. I believe there's a bathroom inside that master bedroom, and we've given you the pictures of this, in which Mr. Shouting profanities, calling her names, doing all these different things around the child, who's terrified at this point, kicks in the door. We've given you the picture of that. This is captured from the Ring camera. So he refers to it as a quote unquote incident. It was significantly more than that. Child is petrified at this point. His dad, who's drunk, calling mom names, engaging the child in what his perceived issues are, kicks in the door. Imagine a 7-year-old little girl under those circumstances when dad's literally acting like a maniac. That's concerning. Directly in front of the child. Fast forward to that, and then what happens? He takes a computer and he smashes it. He goes and he throws himself, which is a new one to me, and he admits this to his credit. It's one of the things he does admit. He throws his body into my client's car. We've given you pictures of that. We give you pictures of the computer. The damage to the car from him repeatedly, essentially body slamming himself into the side passenger door, is extensive. To say and suggest, well, it was an isolated incident, it happened 10 months ago, guarantee you the 7-year-old little girl probably hasn't forgotten about it. Guarantee you this is now branded in her mind and her memories, unfortunately, watching dad do this to mom. Further acts of domestic violence. Look at the text communications. And again, this is very concerning. Again, he's calling my client exceptionally offensive things. He's alleging that she has an affair, which is ironic given his fascination with this 14-year-old little girl at the time. He's threatening. He says, your SHIT is in the front yard. Yes, he's gone ahead and thrown her stuff out the door. Let Tyler know. That's this person he thinks she's having an affair with, which again, she's not. Let Tyler know I'm on my way. Threatening that he's going to bully him or he's a tough guy or he's going to beat him up. I'm about to throw more of your SHIT outside. What do you need out there? These are all separate texts. Then he states, I'm about to make a Facebook post about you and Tyler, by the way. You sure you want me to go to your family about it? He then sends her a draft of this text in which he's threatening to send to her family about the things that he's going to do and about this relationship, which, quote, started out as texting him, but he was pretty quick to be forward and she did not stop at all. Again, and then he goes on and on and on and on about all this. And there's no response by my client, mind you. This will be going out shortly. Doesn't get a response. Okay, then. Where's my watch chart? I mean, so he's constantly prodding, and this can only be described as the typical domestic violence perpetrating activity that we typically see, and it's disgusting. And this is an individual, again, who's been in charge of children who's worked for the department, who's been a state employee, who not only victimizes the young kids that he's in charge of their care for, he then subjects his own 7-year-old to that type of unruly behavior as only domestic violence perpetrators can do, and only somebody with significant deep-seated issues, which I don't know if it's emotional, I don't know if it's environmental, I don't know if it's mental health, probably all of the above, sits there and subjects that to, and then comes to this court and files a declaration under the penalty of perjury saying, well, I can't talk about the criminal side, and there was a small incident from November. Interesting, in counsel's comments, he states, well, he hasn't had a drink since August 31st. That's less than 2 weeks ago by my count. So again, if we look at the totality of this, we look at his actions, not just with his employer and the kids that he's charged to be responsible and provide safety for, but his actions in his own home around his own daughter. There is very little faith or confidence we can have in him that he's not doing similar actions at home. He hasn't learned from it. He's proven that. My client details for you. She didn't have the money back in February to fight this. She didn't consult with an attorney to fight this. She didn't know what she was doing. And although we do have these new forms that are supposed to be more user-friendly, they're not. It's overwhelming and complicated to navigate through this system. My client did the best she could. She had no idea until this summer. When things start happening with the child, we start learning more about the process of the criminal investigation. More and more comes out. And what does Mr. Perez say? They can't prove anything. Well, we proved what happened inside the house with the domestic violence, and that in and of itself is concerning. He says, I haven't had a drink in 2 weeks. That's very concerning. Obviously, everything we are suggesting now is designed and centered to take care of this child, protect her best interest, and ensure her safety, and dad has none. My client doesn't want to disrupt that relationship. What we've supplied you by way of a proposed parenting plan makes sense given the circumstances. Mr. Perez, we believe, still lives with his mom. That's great. And my client is agreeable to grandma watching the child, provided the child on the overnights, which we're suggesting is Saturday overnight to Sunday every other week, provided the child has her own bed, provided grandma signs an oath of supervisor, and provided that Mr. Perez gets the evaluations and gets those underway, which I think are imperative given the circumstances, until GAL can come on board. My client's also proposing every Wednesday from after school until 7 o'clock that evening. That gives the child time with dad, but it also reduces the amount of level of conflict dad can impose, or the amount of significant harm dad can continue doing to this child. I would submit that I think the child probably needs some counseling. I think the child has been through a lot. We have no idea what to expect in December when dad goes to trial. If he's convicted, he's looking at a significant sentencing range for the felonies and the crimes that were alleged. We don't know what's going to happen with that. That's going to take the child some time to work through. Having kid go back and forth between mom and dad given these circumstances without any kind of confidence or assurances that dad is behaving in a reasonable manner, again, is extremely short-sighted, and again exposes this child to undue stress and turmoil that we just assume she not be subjected to. That's our position on the parenting plan. As it pertains to the child support, and again, I think this is interesting. Mr. who has a bachelor's degree, who has very significant work history until he sabotaged himself, was making about $60,000 or more per year while employed in those capacities. We now understand that he's working at Farmers Aid Insurance in Castle Rock. Nonetheless, he's claiming to only be earning about $2,017 per month. If you look at, I believe that was either in his declaration or his financial declaration. Again, that amounts to about minimum wage. Certainly, he's capable of earning more than that. We have no information about what other jobs he's applied to. We're suggesting the court just impute him at a net income of $3,500 per month. Now, that equates to about $50,000, maybe a hair less per year, which again is significantly less than he was making back when he was employed by the state. And we certainly think that is reasonable and appropriate. Also asking, again, that he be pay for a lot of these evaluations. And again, that recognizes the fact that he will be paying for those things, responsible for those. And he's sitting on $40,000 in cash from the sale of the proceeds of the house. So there's ample money there to provide for and ensure this court that he's safe for his daughter, ensure this court that he's dealing with his significant amount of issues in a positive and meaningful way, as opposed to continuing to minimize those. My client's employed at Ulta Salon in Longview. We've given you her income information. By my calculations, her net is about $3,150 per month. And again, we're happy to provide that and put that in the worksheets for purposes of child support. And we need to get that started right away. I mean, my client tells you that she's also going to college. She has future ambitions that she's pursuing. She's about a year or so away from a bachelor's degree, continues to strive towards that, and also working as hard as she can to provide for her household and this child. So again, I think those, as it pertains to the child support calculations, are appropriate given where we're at. My client, from the sale of the proceeds of that house, has about $60,000 left towards that. Again, she anticipates if the court does appoint a GAL, which seems pretty obvious at this point, that she will draw from that, also drawing and paying for her legal fees from that. And that's the position we're in. So we do need some support so she can maintain as much of that, those house proceeds as possible, again, so she can pay for college, pay for her future residence, and get reestablished.
Thank you, Mr. Zandy. Mr. Sasaki, any reply?
Yes, Your Honor. I'd just like to point out that there has been no minimization on the part of my client. I believe that's an unfair characterization. His conversations with Ms. Perez, I believe, are being taken out of context and can be explained away by Mr. Perez's declarations and supported by the supported declarations that were also filed in support of Mr. Perez. Again, the incident with Ms. Perez, although somewhat prolonged, was an isolated incident. The whole deal that Mr. Perez is trying to conserve is the best interest of Addison, his daughter. It's not right to take significant time away from her father based on allegations. Again, the previous charges were dropped. Allegations against male caseworkers are not uncommon. And again, my client has not been convicted or pleaded to anything. Previous charges have been found to be unfounded. He's currently is living with his mother, the individual that Ms. Perez proposed, supervised visitation in her second proposal. So yeah, just once again, we would like to ask the court to adopt my client's proposed parenting plan, which reflects the status quo, and alternatively maintain status quo and revisit after resolution of the criminal case. And if I may also address the financials, we did submit his pay stubs and supporting financial declarations. I believe based on the timeline and the circumstances, I believe that there's no evidence that shows that my client changed jobs in order to snub Ms. Perez from any support. Thank you.
Right. Thank you, Mr. Sasaki. Okay. So as far as the financial aspect of things, I'll find that Mr. Perez has a net income of $2,600 and Ms. Perez has a net income of $3,150. That payment should start on October 1, 2024. As far as a guardian ad litem, I will appoint a guardian ad litem. And so if we could just go through that exercise of the three individuals that are next on the list, and each of you can exercise a strike if you'd like. Madam Clerk.
Next, we have Karen Lawrence, Beth Fellows, Amy Turnbull.
All right. Mr. Zandy?
I have no objections to any of the three, Judge.
Okay. Mr. Sasaki?
I apologize. I wasn't 100% sure on the names. Could they be repeated, please, just to be on the safe side?
Sure. Karen Lawrence, Beth Fellows, Amy Turnbull.
Thank you. No strike on any.
I'll appoint Karen Lawrence to serve as the guardian ad litem. It'll be a private pay. Each will pay proportionally based on those net incomes of $2,600 and $3,150.
And Judge, I would just say I anticipate this might be one where we could potentially run into a conflict or two on that registry. Some of the GALs have been involved with CASA. Can you hear me? I just got a weird message on my computer.
Yeah, it was a little warbly, but I heard you.
Some of them have been involved with CASA. Some of them have been involved with the state. Some of them might be aware of what's happening with this. I just don't want, and I don't know if Ms. Lawrence is online or not. I don't see her, but nonetheless, I'm fine if she's appointed. Just want to get out in front of that issue. They might know information about this case pertaining to Mr. Perez on the allegations of the criminal side.
Yeah, I appreciate the caution and concern there. We'll hear from Ms. Lawrence if she has any concerns. Hopefully she will notify us promptly and we can make any adjustments. So as far as that guardian ad litem report, we'll set a review date or for a final date for the report to be accomplished in 30 days, which would be on a review on December 11th. December 11th is a Wednesday. And that'll be at 9 o'clock in the morning. As far as the parenting plan, so the concerns that have been raised are the criminal allegations that are pending and the former criminal allegations, and then the incident in November, which involved alcohol and property damage. And there's a mention of the text messages that occurred. So, and also there is, I take note of the February 2014 proposed parenting plan by Ms. Perez, and that the explanation as a pro se litigant, and that as a limitation, and that the criminal charges were filed sometime in early January of 2024. The investigation sounded like it started in the spring summer of 2023. So obviously there are obviously some big red flags that are waving related to of minors. And those are non-family members. And there's, at this point, that there's been no mention or concern lifted that there's concern related to family members. So I make that notation there. I also note that with the domestic violence episode in November of 2023, it sounds like alcohol was present, there was property damage, and the child was also present. I think that's not lost on the court. So I think because of those factors there, that a psychosexual evaluation is appropriate, and that should be undertaken by Mr. Perez, and he would be responsible for making payment of the same. The same with domestic violence, and also the SUD evaluation with collateral input for all three from the guardian ad litem and also Ms. Perez. And recognizing that, I recognize that happened 10 months ago and there may not be any episodes prior or past. Nonetheless, it's a pretty significant event, and that I think it needs to at least be investigated through that evaluative process. So that'll be the court's order there. As far as custodial parent, Ms. Perez will be the custodial parent. And I recognize that the parties since February have been engaged in what we'll call a 60-40 split, with 60% of the time the child is spending with mom and the other 40% with dad. And those are rough numbers. So we have that. And so the concern there is, I think this is the unspoken concern that Ms. Perez is making, that if there's these concern and propriety occurring with younger females who are 11 and 14, I think Addison is 7, and that there's concerns that might raise its head here. As I mentioned, that there's no indication that is the case. There's also somewhat of a protective factor of having grandmother of the child living in the same home during the residential time of the father. Nonetheless, there are concerns there. So I'm going to set the custody visitation schedule for Mr. Perez on the 1st, the 3rd, and the 5th weekends as defined by Friday. So Friday at 5 p.m. to Sunday at 5 p.m. and then every Wednesday after school until 7 p.m. And I recognize that's a significant change for the child and for the father from the current practice. I think there's some caution to be warranted. So that'll be the parenting plan. And I think that addressed the issues, and joint decision making, I'm fine with that. And then also, once all the evaluations have been completed, the parenting plan can be revisited.
Do you want, Judge, a couple clarifications? I'm assuming the DV evaluation done by Ms. Lovely and the substance abuse evaluation done at any state certified agency in town?
I'm fine with any agency with the SUD. I know that the DV evaluations, that's somewhat of a specialized niche, however you say it. And so she's local. If Mr. Perez wants to go through her, that's fine. If he finds somebody else that is a domestic violence state certified provider, he can go with them also. I'm not going to dictate which one he goes to.
And then on the alternating weekend and Wednesday visitation, do you want that supervised by grandma, or are you leaving that part out? And are you willing to put in there that child has her own bed and sleeping quarters at night?
I'm striking any supervision requirement. And Mr. Sasaki, does the child have separate sleeping quarters at dad's home?
I apologize, Your Honor. I don't recall.
Mr. Perez?
Yes, Your Honor. She has her own bedroom and bed.
Okay. That should be made part of the order also. Okay.
Yeah.
Go ahead.
I'm sorry, Your Honor, presentation in 2 weeks, unless I have a trial, and I will notify the court and Mr. Sasaki.
I'm fine with the 25th, Mr. Sasaki.
The 25th at 9 a.m.
Mhm.
Yes, that'll work.
We'll set that day for presentation for those orders, including the parenting plan, the guardian ad litem, and the child support.
Very well. I think that's all from our end. Thank you.
Mr. Sasaki.
Yes, Your Honor. May I please clarify, confirm as to the visitation? I have the 1st, 3rd, and 5th weekends, and then I miss after that.
Oh, yeah. 1st, 3rd, 5th weekends, Friday 5 p.m. to Sunday 5 p.m. And then every Wednesday after school 7 p.m.
Thank you. I got that. And I just want to double check that I'm not missing anything. Thank you. I believe that's everything.
Thanks, everybody. We'll potentially see everybody on the 25th at 9.
Very well. Thank you.
All right. Thank you.
Thank you.
All right.
Gonna log off, Joel.
Let me just touch base with, there's 2 remaining cases and we're at 12:45. And unfortunately, I think we need to end of the docket this time. So let me just touch base with Natasha Geis and Jacob Geis. Come on up, Ms. Geis. And I recognize I've asked you how to pronounce that last name in the past, and maybe you can remind me how to pronounce it. Geis. Okay. Thank you. Jacob Geis, are you on the line?
Yes, sir.
Okay. Mr. and Ms. Geis, I apologize. The docket has ran longer than anticipated. This is a motion brought by Ms. Geis for contempt. And it looks like service was proper upon Mr. Geis, and it relates to child support, daycare expenses, and the refinancing of the truck, and kind of the aftermath of all of that. So let me just double check. So we're time crunched at this point. I have another docket that starts at 1:30, and I was going to meet my daughters for lunch at 12:30, so that may not happen today. So I just want to just ask you, if we were to continue this matter to next week, if there's any undue burden in doing so. Ms. Geis.
That's fine.
Okay. I apologize. Mr. Geis.
I would just like to address the matter at a timely pace.
You'd like to address what?
The matter at a timely pace. That's all. So
yeah, and I think if we're to address it today, there may be a sense of being rushed, and so are you comfortable with setting it over 1 week to next week, the 18th of September?
Yeah, I'll notify my employer.
Okay. And again, I apologize. I recognize it's a significant investment of your time to get here and then have the case continued. So I apologize for that. So we'll set it over to 1 week, and I'll do my best to call it early on the docket.
Okay. Thank you, Your Honor.
All right, we'll see everybody then. Thanks.
Thank you.
Next, I have Zach Bissig and Megan Gibson, 23-3-30808. As I see Ms. Call is on the line, and then we've got Zach Bissig present in the courtroom.
Yes.
And then is Megan Gibson online?
I am, Your Honor.
Okay, very good. So as you heard me describe just earlier with the other group, we're at a point where I think we need to continue the matter, and I apologize for the wasting of your time. That certainly is not my intent, nor do I like to do that. This is on a motion brought by Ms. Gibson regarding contempt, and also just a quick review from the guardian ad litem, which has implications related to parenting plan. So my request is from the parties to set this over 1 week and hopefully address it earlier in the docket rather than later. And I just want to know, does that impose any undue burden on either party? Mr. Bissig, start with you.
That sounds good to me.
Okay. All right, Ms. Gibson.
I have no objections to that, Your Honor. I'm just curious on if you can ask Mr. Bissig if email service would be okay for the documents that I've been trying to get him served for.
Okay. Mr. Bissig, do you have a position related to electronic service of documents?
No, I'm okay with that. I can do the same.
I'm fine with that.
Okay. Do you both have each other's email addresses?
Yeah.
Yes.
Okay. Yeah, I'm fine with that if you want to do that. And then Ms. Gale, how about your schedule?
I'm a little jammed up next week, but I will be here.
Okay. I appreciate everybody's patience and flexibility. And again, my apologies. We weren't able to address the case today. So we'll set over 1 week, September 18th, 9 o'clock, and I'll make sure that we hear it earlier in the docket rather than later, so this does not happen again.
All right.
Okay.
Thank you, Your Honor.
Thank you.
All right. That will conclude the case. Let me just check with any party that's online if you were anticipating your case to be called, but it has not yet been called. Okay. Not hearing any response. That'll end the docket. I'll go ahead and end the Zoom call. Thank you.